Good evening. Welcome to the Food Well Alliance and the Law Farms Farm Law webinar series. I will take a second and thank Food Well Alliance for their generous support of this resource for farmers in Georgia. They've made this webinar possible, as well as one-on-one office hours with me, a practicing attorney, to ask any follow-up questions you have and to go into more nuance with these issues that we're going to bring up tonight. For those folks farming in the 5-county area that Food Well Alliance serves, the office hours I'm going to talk about are completely free. And for everyone else, I'm going to make it very accessible for you. And of course, this webinar series. So this month we're talking about intellectual property and all the IP, which is just a shortened version of intellectual property, all the IP issues that may impact farmers and value-added products. We've talked about some other things in the last few months, and on the agenda coming up, next month we're going to be talking about some tax exemptions for farmers, and I'm going to talk about some funding issues with federal funding that's available for farmers. And we'll be doing employment law after that and talking about volunteers on the farm. And then in December, it feels like a good slow time to just do a complete business law nuts and bolts boot camp style webinar. So we'll talk about important agreements and important legal foundational pieces for a farm business from cradle to grave. But let's dive into our intellectual property material for tonight. Oh, excuse me. Before we dive in, got some housekeeping. Have something to take notes. If you're watching the recording, grab a notebook real quick and just dump everything that's on your mind right now, first and foremost, to stay present, get everything out of this webinar. If you're thinking about your to-do list for tomorrow or something that you left untaken care of today, go ahead and jot it down. Get present with me. Stay focused. I'm going to present so much information very quickly, and I don't expect you to catch every bit of it. Make note of what sticks out, and let's have those questions more expounded on in office hours, or it'll be something to think about when you have some downtime on the farm. Don't feel any pressure to keep your camera on. I do love seeing faces. Makes me feel like I'm not just talking to myself on a screen, but don't feel any pressure to keep your camera on. Make sure you're muted if you're not speaking up to ask me a question. And I will take questions at the end. I also welcome you to go ahead and type questions that come up in the chat box. I'll try and keep up with them as I'm going through this presentation, but I'll definitely check in with them in between sections and make sure I get all those questions that were jotted in the chat box. And I'll be sharing some resources with you on trademark. Excuse me for 1 second. I'm going to share some resources, and I invite you to follow along when I share those resources and get a feel for what it feels like to be on those sites, to actually do those searches yourself. And I'm here right now to ask questions if anything comes up. And of course, I'm a lawyer, so I come with a disclaimer. It's very characteristic. This presentation will not provide legal advice. Legal advice is nuanced and it depends on particular details and applications of the law. And I don't have the ability to give each of you that tonight. But this presentation will provide you with legal information and education. This presentation will guide you to transform dense law into clear action steps for your farm business. And it will empower you to integrate legal tools into your farm infrastructure as you grow. There is no attorney-client relationship created in this webinar, and there's no confidentiality preserved with what you share. So when you ask questions for Q&A, keep things high level. Think of a hypothetical framework, and if you have specific questions that involve more details, let's use those office hours to go through that. Here's what we're covering tonight, and this slide is deceptive because it looks maybe like a manageable amount of information, But I said it before, I'll say it again. We will be drinking from a fire hose tonight. I am going to fire off a lot of information, a lot of nuanced law that could definitely be teased into an entire series itself. But here's an overview of what I want to accomplish with y'all tonight. First, I just want to talk about intellectual property in general and why does it matter to farms. In marketing this webinar, I've had a few people ask me what IP has to do with farming. And it might not have anything to do with actually putting seedlings into the ground or getting food prepped for selling at market, but it kind of does actually, you'll see why. And so we'll talk about IP and what it means to farms and food businesses. And we'll do an overview of common IP that's applicable to local food and farming. This includes trademarks, copyrights, patents, trade secrets, plant variety protections. We'll talk about it all. Each one of these topics can be an entire class at law school. So again, if you feel lost, if you feel overwhelmed, this is recorded. Go back to it, slow it down, take notes where it matters, leave the rest. This is just a huge overview of intellectual property, and it's meant to guide you to have the right questions to ask in office hours and to make sure you're taking advantage of these IP protections we'll talk about. So when it comes to intellectual property, I mentioned the word protection. So how do you protect your intellectual property rights and how do you avoid infringing upon others? So we'll talk about cease and desist letters tonight. We'll talk about licensing agreements. We'll talk about non-disclosure agreements. If we have time at the end of the webinar, I have a sample licensing agreement and a sample non-disclosure agreement that we can actually go through together clause by clause. I think it's great to see the language that are in agreements like that, to think about the nuance that goes into writing those agreements, what should be there, what doesn't have to be there. So if we have time, we'll go through those agreements together. Both of those types of agreements have applicability outside of the intellectual property realm as well. So they may be useful in other areas of your business. And I was going to include other ways IP has impacted farming and talk about Monsanto a little bit. Again, that'll be if we have time after those agreements. And especially if it comes up, if y'all are interested in it, I can give you a quick overview of the Monsanto case that made it to the Supreme Court and that is often referenced in terms of big business coming after what might be considered a smaller scale farm business for infringing IP. We'll talk about those sorts of things too. So what is intellectual property and why does it matter to farmers? Because it does. Intellectual property is just that. It's taking something that's intellectual, something that's creative, something that's an expressive piece of work even, and it combines it with property law to give you rights to that intellectual property that you make. If you paint something, if you choreograph a dance and you write it down, if you write a recipe for a value added product, if you create a new invention, all of these things are start as creative endeavors and pursuits, and we're giving them property rights and intellectual property. So I'll reiterate that again. It's a set of property rights associated with things we create. Intellectual property can contribute considerable value to a business. So in a valuation, if you were going to sell your farm business or if you were looking to purchase somebody else's farm business, part of the valuation process or figuring out what the dollar amount of that business is would involve putting a number value on the intellectual property. So whoever's assisting in that sale or getting it together, or even if it's just the two business owners themselves having that conversation, you're going to have to talk about, do you have trademarks? What are they worth? Do you have any copywritten material? What is it worth? Is it licensed to anybody? But there can be considerable assets in intellectual property. Creates more value for a business and more equity, more money, and more wealth in this small scale sustainable farm and food world. And when it comes to particular farm intellectual property, many farms rely on value-added products to increase revenue. So before it even becomes a basis of evaluation of the business, it has to do with the day-to-day revenue. And these value-added products that farms create, they range from prepared foods to educational courses, branding, social media content, and standard operating procedures. And all of these fall into different intellectual property categories and have different ways that they are protected with property rights, and they have different ways that they're registered, different ways they're enforced. And knowing and understanding that nuance is going to help you to capture that value in your business. And when I say capture that value of your business, it does bring up the moral and ethical issues of intellectual property. There are two extreme schools of thought on this, and one of them would be protecting all of your intellectual property vigorously, having it registered, enforcing it diligently, and putting a monetary value on everything you create. And on the opposite end of that spectrum is an open source mentality, is a cooperative mentality of thinking, yes, I may have created this idea and it does create value for my business, but I want to be able to share it with others and help promote the technology in that space. When I use the word technology, I use it loosely in the sense that the wheel is technology. The way we do things on farms is also technology. So there's two extreme schools of thought. It's make everything IP, put a value on it, strictly enforce it. And there's a school of thought of these things should be shared, maybe especially in sustainable farming where this matters more than just a bottom line. Both of those opinions have a time and have a place. And I think there's an entire spectrum in between those where a farm business might lie. And it's important to think about one, your own personal moral and ethical views on that. And then two, the implications of having equity and having revenue in a movement. If you think of sustainable farming as more than just a bottom line of a business, if you're thinking about the people and planet aspects as much as the profit, think of all those moving parts together and decide where you stand. And that'll help influence your decisions on what you are going to consider intellectual property, what you might register, and what you might enforce. You may think of and I'm not going to go into hypothetical land, but yeah, take a minute, either after this webinar or when you sit down to do your business stuff when winter comes, and think about where you stand on this and how diligent you'd like to be in intellectual property. And I'm here for the full ranges, and I understand the merit behind the arguments in both of those camps. And so I do want to mention cottage goods. Before I jump into the intellectual property, I want to do a quick plug that cottage goods are governed by Georgia regulations, and this is an easy access point for value-added products in terms of prepared foods. It applies to goods being sold direct to consumer, and there are other licensing implications once you start selling to retailers, restaurants, or other institutions. But I think these cottage goods, it's just the easiest and most simple entry point. If you want to make value-added products in the form of prepared foods, this is an option without a whole lot of moving parts. There are some steep requirements, I think, in terms of being able to manage your own kitchen, kind of like a commercial kitchen. But it's a very easy access point, and you can use office hours to talk through these regulations. You can talk through the regulations and the licensing of selling to retailers, restaurants, or other institutions. That's something we can create a game plan for your farm business, for your food business together. And I just want to mention it here before we move into trademarks, especially because a lot of these goods are going to be goods that you may consider putting a trademark on. And I just want to let you know that I am here to help you with that game plan long-term, starting from using your own kitchen to create these things all the way up to being an international online product that folks can get anywhere. All right, so let's go on into the intellectual property. Here's where it's going to start moving quickly. I'm going to start in depth. If anything confuses you, like I said, you can throw your question in the chat, and I will try to keep up with those in between sections. If you feel totally lost and you need to just go ahead and take yourself off of mute and ask me to pause, I'm okay with that scenario as well. And I want to make sure that everybody gets their questions answered, but also keep in mind that I'm throwing a lot at you, and office hours are available to talk through anything in more depth if you need. All right, so Trademark 101, you may have seen that TM, the SM, or the circled R on goods before. Those are the marks associated with trademark. And this is the quality protection intellectual property. And a trademark indicates the source of the goods that you're getting. So some types of applicable intellectual property would be your hot sauce label, your jams and the name of those jams, or preserves, or pickles of any kind. Any branding that you put effort into. Farms, rightfully so, take credit for having a culture of sustainability and a culture of community, and that's part of branding. So a trademark helps preserve all of those branding pieces that you work so hard to put into place, and make sure that your customers and your folks who are looking for you can find you and know the source of the products you're making. And this is what a trademark is on a very basic level. It's any word, phrase, symbol, design, or combination of these that identifies your goods or services. A trademark is meant to distinguish your goods from competitive goods and identifies the source to help distinguish your goods from competitive goods. And it provides legal protection for your brand, because again, your delicious product may be one part of your brand, but a commitment to community, a commitment to sustainability is another part of your brand. Excuse me for 1 second. And this helps guard against counterfeiting and fraud. If you make a hot sauce and it is known around the region and people come far and wide to find that hot sauce, you don't want somebody to be able to slap your logo or slap the word or phrase that you use for that hot sauce on their own label and try and benefit from the goodwill and the effort that you've put in your brand. A trademark is going to give those property rights to how a word or phrase is used with you. I apologize for the amount of character that my dog has this evening. Sorry. It gives rights to how a word or phrase is used with your specific goods or services. And I will give an example of this later. We'll do an actual trademark search. But that's kind of to keep in mind that just because you may have seen a phrase be trademarked before doesn't mean it's going to exempt you from being able to use that same trademark. It has to be farm and food specific if you're doing a trademark for farm and food. So if somebody has used, well, I'll use the specific example that I have later instead of going into hypothetical land here. But just keep in mind, it's to specific goods or services. Creative and unique trademarks are more effective and easier to protect than anything generic. And the next slide is going to illustrate that point. And then trademark protections last until you stop using the mark. So that could mean that even after you pass away, if you give, excuse me. And here's what I mean about that creative and unique trademark. If I know I'm going to be putting something on a label that's representing my specific brand, I want to start at the top of this chart And as I work my way down with different options, I'm losing the strength of my trademark. I'm losing the strength of my ability to set myself apart from other folks who may be selling something similar in my goods or services realm. So at the very top, that strongest type of trademark is going to be a fanciful trademark. And the language I've used in those orange arrows is language that the trademark office uses. So if you were to apply for a trademark, you're going to see language like this in describing the trademark you're using. That's the same language that's in those arrows. So a fanciful word is made up. So let's say I'm going into the peach jam business. I'm going to start selling peach jam, make a whole business around that. And I want to make sure that when people buy my peach jam, they know they're buying the peach jam I have put my heart, my soul, and I've invested in product research around, and I get the best ingredients, and I take care of my employees and pay a living wage. And I want to make sure that people know that when they buy my brand. I may want to name it something that's a word that I completely made up, like peacherific. If I have an arbitrary trademark, then I'm using a word that has a meaning somewhere else. It's a word that's going to evoke some other characteristics, but not in the products or goods that I'm selling. So for instance, hip hop has implications in music and culture, but maybe not necessarily peach jam. Another example of this is Apple computers. Apple really doesn't have anything to do with technology, but they've used this arbitrary word in their goods and services. A suggestive trademark lends itself to folks being able to understand or evoke a sense of what your product is making available. So a suggestive peach jam trademark might be Georgia Sun. It kind of gives that feeling of summertime and peach season and what that peach jam might entail. And a descriptive or a generic trademark are going to be hard to register, and they're not very strong trademarks. So if I decided to call my peach jam Sweet Peach, well, a lot of peach jam is sweet and a lot of it has peaches. So it doesn't make that clear delineation that this is my peach jam and my business's product. And likewise, a generic term would just be peach jam. Not very strong, not likely to get that registration from the patent and trademark office. And this just illustrates when you're thinking of what do I want to call these products? What do I want to, and you can also trademark since it can apply to a service as well. You can think about your educational materials and what do you want to call your courses? What do you want to name your any electronic resources that you put out there? Think about that trademark and creating something along the fanciful lines. And I think this is a common misconception with intellectual property in general. Ownership of a trademark applies when you start using your trademark. The rights are going to be very limited in that scope, and it's likely only going to apply to the geographical area you're using in. So to illustrate that a little bit, if I went into the peach jam business and I put peacherific on my container, that's my trademark. And I should have done due diligence, and we'll go through this in detail of what that due diligence looks like to make sure that I'm not infringing on anyone else's. Once I've done that, I slap peacherific on something. That's going to give me some right to enforce my intellectual property rights, but it's going to be very limited. For instance, if I am only selling at Freedom Farmers Market on Saturday morning and I have one stand and that's the only place I sell peacherific, if I find out that someone in Valdosta, Georgia is selling peach jam with the name peacherific as well at another market, I can't really call them out for that trademark. If I sent them a cease and desist letter, it would kind of be out of place because I don't have that right there without registration. So with trademarks, you can register them at the state level or the federal level. And this is going to give you more broad rights to assert your trademark and to make sure that your brand and your materials are being protected with the property rights that they should be. This applies nationwide. So with my hypothetical peach jam business, if I decided to sell online in gift baskets and like really promote a nationwide product, which is very doable these days with the internet, I think more so than they may have been when these intellectual property concepts even began and became a body of law. Now it's so easy to go nationwide and to want to protect that trademark and to protect your brand. That federal registration is going to do that. It's going to make sure that even if you're selling in Washington State, you will be able to assert that trademark there. So if someone starts selling Peacherific jam in Washington State after I've already started, using my trademark and I have it registered, I can send them a cease and desist letter and let them know that they're infringing upon my intellectual property rights and they need to stop by a certain time. Some other benefits of registering, because like I said, you own your trademark as soon as you start using it. But another benefit or a list of benefits of registration are that you have the legal presumption of ownership once it's registered, which means if you did have to go to court to enforce your intellectual property, you wouldn't have to spend a lot of time showing evidence that you actually own it. Your trademark is that legal presumption, or your trademark registration with the United States Patent and Trademark Office creates that legal presumption. And you have a basis for foreign filings. And again, with the internet, I don't think it's outlandish at all to think that even a small scale food business in the Atlanta area could end up having a presence in a foreign community. I think it's very possible with the internet, with social media, and with the way the global world that we live in. Registering with the Federal Patent and Trademark Office gives you a basis for foreign filings if that becomes necessary. It also gives you the right to bring the infringement suit in federal court if need be. And it allows you to use the R with the circle around it. Let me go back to that slide that had the different marks. The TM is used for a trademark, whether it's registered or not. You can slap the TM on your logo and it starts to put folks on notice that this is your brand, this is your trademark. The SM is used if you're providing a service. And that R is something you get to use once it's registered with the United States Patent and Trademark Office. That's when that R comes in and you can use that. Using the circle R without being registered can have some penalties associated with it too. So it's not just improper, it's actually a penalizing thing. Before I go on to copyrights, do I have any questions about trademarks? You can throw it in the chat or you can just chime on in, take yourself off of mute. Any questions? Awesome. We'll move on to copyright. You may have seen the C with the circle around it. That's the copyright symbol. And copyright is the original creation intellectual property. And this for farm value added products includes social media content, educational courses. It could be pamphlets, brochures, any sort of information that you are creating and handing out for agritourism. All of this stuff is going to fall under copyright. There's also some overlap between trademark and copyright. For instance, you would get a trademark registration for a logo, like a picture logo, so that folks know that that is your brand, it is on brand, and it's coming from you. But you may also have a copyright protection associated with that logo, especially if it was a work that you created. And there's implications if you're hiring folks to create logos for you. There's implications about copyright ownership that should be kept in mind as well. So the basic copyright overview is the copyright applies to artistic, literary, or intellectually created works. They must exist in a tangible medium. And to illustrate that purpose, if a speech was given outside in a garden and the words weren't written down and it wasn't recorded in any way, that speech may not be copywritten. Those words or that lecture may not be copywritten. But once it's in a tangible medium, you write down the words of that lecture, you videotape it, and I don't have certainty on this example, but I would go as far to say when you do an Instagram live or you do a Facebook live video, I would consider that to be a tangible medium that's copyrightable at that point. Copyright is going to protect your exclusive right to reproduce, distribute, and to perform or display the work. It gives you the right to keep making it, to keep using it, and to keep being able to benefit from any commercial aspect of that. And it prevents other people from copying or exploiting the work without the copyright holder's permission. And we'll talk about how you can give that permission and exchange that permission in relationships. But just make sure that your work stays your work, and you can count on anyone using it to be using it for the right reason, which I'll get to in a minute, or with your permission. Just like trademark, work is under copyright protection the moment it is created and fixed in a medium. So as soon as you make an Instagram post, as soon as you write a curriculum for an educational course, as soon as you draft standard operating procedures for your farm, all of these things are copyright protected the moment they're created and fixed in a tangible medium. The second bullet point shows you what a copyright notice looks like. And so you can add this to anything you make. If you've ever used a website template form, they usually put this on the bottom automatically for you. And this is something you can add anywhere. The circle C with whoever the author of the work was, and then the year. It's no longer required to be on copywritten material, and it's not a substitution for registration. But I think it's a very helpful way to put folks on notice. It's a little bit stronger than a watermark on a picture on Instagram or something. And it just puts people on notice to let them know that you created this and it has value to you, and they should respect the rights that come along with that copyright. It's not required, so you can still enforce any copyright rights that you would like to, but I think it's just amicable to go ahead and put some kind of notice. And I mentioned a watermark. On social media, you may have noticed that people will put their handle in a conspicuous place on a photo that they're uploading to make sure that even when it goes viral, they're still going to get that credit. So a watermark is another way to give yourself that automatic credit for copyright, for people using a copyright of yours. Now you do get benefits with registering your copyright, just like with trademark. Copyright registration comes with a host of benefits that are very similar. You need that registration to bring a lawsuit for infringement. That copyright registration is going to be evidence of the validity of your copyright. Again, it just saves time and evidence and having to prove that that was your copywritten material. And also, if you have a registered copyright before the infringement takes place that you have to enforce, or within 3 months of publication of that copywritten work, you have access to statutory damages. So damages just by law that you have a right to for somebody infringing on your copyright, the payment of attorney's fees, and costs to bring that infringement lawsuit. So if you have a copywritten body of work that is of value to you, I think the educational course material is a really good example of this. If you're hosting a course, a 6-week course on gardening or on permaculture or on, or even some sort of mentoring course to help folks get their business together, if that's a big part of your bottom line and a big part of your business's model, you do want to protect that copyright, and it's worth registering it to make sure that you can enforce it as much as need be. And with copyright in general, registration lasts for the lifetime of the author, plus 70 years. I say in general because that changes a little bit if the work was made by multiple authors or if it is a work for hire piece. But in general, it's the lifetime of the author plus 70 years. And this fair use doctrine is section 107 of the Copyright Act. I think is really important to bring up for a couple of reasons. One, people can fair use your copywritten materials, so keep that in mind. And also to promote creativity and to promote access to information, there are certain uses of somebody else's copywritten material that are fair use and that permits an unlicensed use of copyright protected works in certain circumstances without having to have permission from the copyright owner. And the 4 factors are here, but instead of reading them verbatim, you're welcome to take a screenshot of this screen if you want to save them to be able to reference later. I also urge you to check out section 107 of the Copyright Act if fair use is something you're interested in making sure your use falls in line with.
Michelle, would something like this be an example where, say, for instance, I don't know, one of us maybe wrote a book and somebody referenced it in a academic piece, but then they gave, I guess, listed us in the credits of their academic piece. You know, you have to list your sources. Is that an example of this fair use?
Yes, that is an example that is giving a lot of credit to that copyright for sure. If they've got a reference in there, that's fabulous. That's a really good way to show that you're using it in this fair use realm. But it even, Chris, it's a great question. It even lends itself to if you have if you've read a book on cultivating a certain seedling a certain way, and you created an Instagram, video about it, and you just kind of take like one idea out of the whole context of the book and just throw it in there purely for education, and you're not making any money off of it, that even falls into fair use in some cases. So yes, this doctrine is what allows you to use other works to promote education, to get it out to more people in a fair way. The example that you pose with having something referenced in an educational piece, I think that's taking really great steps that we should all be taking, especially with social media. It doesn't hurt. We'll emphasize this again when I talk about infringement, but just giving someone credit goes so far with keeping yourself from having an infringement case brought upon you. I think that's kind of extreme, but even a cease and desist letter. So in thinking about, am I using this for fair use? I think some of the things to really keep in mind is, are you a nonprofit or are you a for-profit business? For-profit business, it looks a little bit sketchier to be using somebody else's work. If you're for-profit, do the legwork and come up with this stuff or pay somebody to use it. But nonprofits have a little bit more leniency in this space to use other copywritten works. And then what's the purpose? Even if a nonprofit is using it, are they using it to make money? Are they putting it into a course that they, will help their bottom line, will help their income and their revenue? Or is it just for education? Is it a pamphlet to get that material out because it's important? The nature of the copyrighted work itself, I think with the case that you posed of having a scholarly article, you're probably not going to get a cease and desist letter from a scholarly article that you reference in something else too, as much as you would somebody's educational course that they created for their livelihood. And are you copying the whole thing and calling it yours, or are you just taking one idea, one phrase out of many to kind of to highlight it, just to promote that work in and of itself? And then, of course, the monetary value, the potential market. Are you upsetting somebody else's bottom line and revenue? Are you, hurting their right to that? So all of these factors are in play. And this is one of those places where getting legal advice on this would really involve like here's what I want to do. Here's what I want to use. And I'm nervous about it. So can I do that? That's a conversation to have one-on-one to talk through all those variables and moving parts. But this does exist. You can use people's work as long as it is under this fair use legal doctrine. And I think it's important to highlight some of the agreements that you may already be privy to with social media and copyrights. I pulled this language from the Instagram frequently asked questions, I think, and then the Facebook terms of use specifically, just to show you that there are intellectual property agreements that that govern this sort of thing, especially in social media, and the terms are accessible. They're available. You just might have to do a little bit of digging to see them in particular. And I will go ahead and nip the myth in the bud that Instagram owns your material. They may have at some point, I'm not sure, but as of the language and the frequently asked questions that I pulled today, they do not own any of your content, but you grant a license for them to use it to be able to continue functioning. Like they can't host your material without that license to have it there. It would create a weird loophole. So they don't claim ownership over any of your material. You do give them a license to host. I don't know. Let me see if I can mark. I'm trying something new. Yes, you give them the right to host, use, distribute, modify, run, copy, publicly perform, or display, translate, and create derivative work. So that is a broad license, but notably, it is a non-exclusive license. So that means you can still license your work to anyone else that you would need to run your business. It's royalty free. They don't have to pay you. You're using their technology. It's transferable, sub-licensable, and worldwide. So yeah, some interesting implications there, but they don't own your work. They're just licensing it to be able to do what they do for you to have that platform. Now let's talk about the Facebook protecting the rights of others language. I do want to point out that Facebook owns Instagram. So if you're curious about the terms of use for these apps in particular, you can always turn to the Facebook terms of use as probably applicable in the Instagram case too, because Facebook owns Instagram. So the agreements you have with Facebook likely apply in the Instagram case as well, or in the Instagram instance. And this Facebook language illustrates how important it is that you're still thinking about infringement and you're making sure that your use of somebody else's material either falls clearly under the fair use doctrine, or you've had a conversation with them and made sure that it was all right that you use it, and find out what terms they need to make them feel comfortable with you using it. When you're using Facebook, you are agreeing that you will not provide or promote content in your app that infringes upon or otherwise violates the rights of any person or third party, and that you will obtain all rights necessary from applicable rights holders to license that work. So they're putting the responsibility on you. If there's any infringement on Facebook or Instagram, that's your burden to bear if you were the cause of that infringement. And yeah, and whenever you use them, you're agreeing to those terms, that you're going to make sure to be diligent and to not infringe somebody else's work or ask for the rights if need be. I think that's the last of the copyright questions. Oh no, talk about license agreements. So we talk about that license that Instagram has to use your material, and license agreements are something that you can use to give somebody access to your intellectual property, to let somebody use your trademark to sell your products. License agreements can help you promote your intellectual property, to use it for more marketability, to just have more flexibility. And it can be super short and sweet, or it can be a little bit longer and more drawn out depending on the value of the intellectual property, the implications of somebody using it in the wrong way, etc. But some things to keep in mind with license agreements are, well, first of all, they give you an opportunity to grant someone the right to use intellectual property for limited uses and terms. You want to think about who are the parties. Is it your business's IP? Is it an agreement between your business and an individual, your business and another business, an individual and an individual? Who are the parties? What rights are being granted? Let me go back to that Instagram. They talk about non-exclusive. So that means that other people, you can still license this work to other people. Do you want your license with somebody else to be exclusive or non-exclusive? Do you want them to pay you a certain amount? If so, how much? What do they need to pay you for certain rights? Maybe they can use it in one context and only pay you a percentage royalty, but if they use it in another context, you want a flat fee for that. All of that can be worked out between you and the other party, captured in an agreement, and it can help you CYA, cover your assets in your business. And then what limitations are in place and what happens if the IP is misused? So if they do go outside the bounds of that agreement, is it required that the agreement is terminated at that point if they go outside the bounds, or does that just mean that you get a certain amount of damages for them having done that? You kind of get to create your own body of law and how you share and how you collaborate with your intellectual property when you do business. That's the end of copyrights. Are there any questions? Awesome. We will keep checking. This last section, I'm really throwing in everything in the kitchen sink that applies to new invention intellectual property. When you create or invent something, this can be systems that you use on your farm. This can be systems for food safety, automation, and making it quick and easy. Standard operating procedures can fall into this realm. And so can plants. The plants that you're planting, the seeds that you're using fall into this last big everything in the kitchen sink category of patents. And PVP is plant variety protections and trade secrets. And I'm going to avoid reinventing the wheel. So I'll let you know that if you want more information about patents in particular, I think I will glance over it in the next slide. But if you have patent questions, there's a resource for that specifically. Georgia Patents is an arm of Georgia Lawyers for the Arts that helps inventors find pro bono representation to file a patent application and to receive a patent. So if you have patent questions, this is the place to go. I'm a generalist. I provide all sorts of business, legal, transactional resources, but Georgia Patents, they zone in. Patents are what they do. They host workshops, they have resources available, and I want to give that plug. I actually interned at Georgia Patents my first summer of law school. It's a phenomenal organization. They're very dedicated to taking care of inventors and making resources available. I would use that resource so I don't have to go through the whole thing and reinvent the wheel. There's a resource for that, Georgia Patents, and you can find them at gapatents.org. And they have different pricing structures based on if you're an individual or a nonprofit or a for-profit. And I think none of them are more than $300. So for a business, it's a very approachable price, and they'll take good care of you. And there are two patents. Maybe I didn't do a slide on. Nope, I didn't. So a patent is our government's way of saying, tell us about your new invention, disclose it in detail of what the invention is, how you did it, how it's functioned, how it's formed, disclose all of that to help promote technology, and we'll give you this really enforceable protection for that intellectual property for 20 years, give or take. So plant patents exist, and that's where you can patent a particular type of plant, like the plant itself. And I say that multiple times, to then get to utility patents. Utility patents apply to plants, but they usually refer to one function of a plant. So the Roundup Ready gene that is in certain seeds is protected with a utility patent, whereas a lantana nugget, which is a beautiful, vibrant yellow lantana plant, is provided under, or has the plant patent protection. If you would like to go in more depth with any of those, I'm going to in a little while, but again, schedule an office hour and we can talk through these things for sure. And then there's also the Plant Variety Protection Act. And I want to just use this table to talk about all three together in context of the implications of what you can and can't do with certain plants. And I'll mention the Monsanto case here. So I believe it is fairly out there in the non-law world that Monsanto sued a farmer, and it made it to the Supreme Court for using their patented seeds. And the story sometimes has all sorts of different bends on it, right? It's just like the game of telephone where things change and move. But the long and short of it is, the farmer that Monsanto sued in that case, they sue lots of people because they're very, very diligent about enforcing their intellectual property rights, which is fair. I'll get to that in just a minute too, about how important it is to enforce your intellectual property rights. But a farmer bought seed from a grain elevator that the farmer knew had the patented seed in it as well. And instead of using it for feed, he used it to plant. So he had access to this patented seed without going through a license. Monsanto proceeded to sue him for intellectual property infringement, and they won. And then he appealed to the different levels. They went to federal court, and then it went to the Supreme Court, and it was upheld all along. Eventually, or wait, no, maybe that was the Canada case. Let me not go any further with that. So the point I make with that is that when you have intellectual property, you do want to enforce it. It makes sense. It's how you keep the strength of your intellectual property to contribute to your bottom line of your business. But that can be a little bit scary when you're the farmer who is using possibly protected plants or possibly protected seeds. Like, what can you do? What can't you do? Especially in the sustainable farming and growing world, where saving seeds is an important function of sustainability in general, of having that integrity of different types of plants and being able to share in that open source worldview and everything. So this table I actually pulled from the Tennessee Extension Office, and I have the information down here of the title was A Green Industry Guide to Plant Patents and Other Intellectual Property Rights. And you can find that online to find the entire, excuse me. The entire article was very interesting to me. I think it did a good job of talking about the different patents and plant variety protections and the nuance of each of those. And then this table is just a gem of a resource. I really urge you to take a screenshot of this if you're on your phone or if you're on a computer. Capture this slide, especially if you're growing plants, if that's what you do. So it has the plant patents, the utility patents, and the plant variety protections. It talks about the type of plant that's eligible for protection, if the plant can be used for breeding or research, if the can the plant be reproduced sexually for distribution or asexually for distribution? So sexually would mean open pollination and saving the next seeds or the seeds that come from that open pollination. And the asexual reproduction is any sort of grafting or don't know all the other words, but taking the actual plant, propagating it without having to have the seed. So, spoiler alert, for all of these protections, the plants cannot be reproduced asexually for distribution. I find it interesting that they don't mention reproducing asexually for use on your farm, but I kind of interpret that to mean that even if you reproduce something to use on your farm, you would want to be cautious of selling that actual fruit or vegetable in distribution, of putting that out there. Can you save the seeds? So for plant patents, yes, you can save the seeds, but you risk infringement claims if the next generation is similar to the parent plant. So if it comes out different enough, sure, go ahead, try that on for size. But if it's very similar to the parent plant, there is a risk there of somebody enforcing their intellectual property rights. With a utility patent, so that would be like the Roundup Ready seed, you cannot save seed and use it in the next generation. And for plant variety protections, you can save seed, but you cannot sell or give it away. You can only plant it on your land and use it again for your use. And the issuing agency down here is a helpful tool too. If you're looking into a plant patent or trying to find plant patent information, the United States Patent and Trademark Office is the place that you want to go. If it's a utility patent, it's also the USPTO. And if it's a plant variety protection, there is a special US Plant Variety Protection Office that has the certificates of protection that you can go look at and learn more. It's very interesting, actually, to look at the plant variety protection certificates and see how the plant was made. They have pictures of the actual produce that comes off of it, like the fruiting bodies. Very interesting, fun stuff to look at, just to think about the plant varieties that are out there and who created them and how, and now they're protected with intellectual property protections. Interesting stuff. Any questions about that? That's a particularly large amount of information that I'm just throwing out there to y'all. Any particular questions? So here's some action steps. Oh, Chris, did you have a question?
Yeah, I was just going to say, like, okay, so for the most part, if it's not something that's already pre-patented, so say, for instance, I'm out in nature foraging, I come across a beautiful elderberry, has super big berries, and I decide I'm going to propagate that particular plant or whatever. That's something that's eligible for me to move forward with. But say, for instance, through like genetic testing, they determine that it's not, I guess we wouldn't be able to use it, right?
For expound on the genetic testing piece.
So basically, there's like a process within the plant world to make the determination around, I guess, true plant. So say, for instance, that lantana nugget, North Carolina farm said, Chris, we feel like you've been propagating and selling that plant. And I said, no, it's not. It's the banana nugget lantana plant. So, there's a way that they could do some genetic testing to determine, if it's the lantana nugget or the banana nugget plant.
Yes, likely. Either genetic testing or the, let me think, the lantana nugget is a patented plant. So like when you look at the patent application, they go into such specifics about what separates that plant from the other lantana plants. So they could use genetic testing. They can use the different points of reference that they have in their patent application. Yes, if they think that it's yours and that you're making a lot of money off of it at their expense, they have many nuanced ways to show that it is that plant protection. I apologize for the dog again. He's very excited about intellectual property. Did that answer your question, Chris?
Yes.
Okay. So on farm, actually making use of this and trying to avoid plant IP infringement, here are some just user-friendly tips that I think are worthy of putting in place. Go ahead and make note of all plant varieties that have IP protections that you use. And if you're not sure at all what plant varieties that entails, start doing a little bit of searching. I think it's, let me not say that. We'll say nurseries should have notice for you. If it's a plant patent, it should have a PP on it and then a number behind it, or PPAF, plant patent applied for. And the nursery should have that on there. If they don't have it, and I think, yeah, this last bullet goes to that, you're not likely liable for damages if you're not put on notice that there is a plant patent. And that parenthetical information there is just to let you know that I looked at a couple different nursery sites online in preparing for this, and North Carolina Farms is a good example of a seedling company that denotes patented and non-patented plants pretty clearly. They have that on their list about the about each item. You can get that information. And then I added the lantana nugget. That's one of the patented plants that I found. And I added that for your reference. If you find yourself on a seedling or a nursery website, look up the lantana nugget. It's definitely patent protected. And if you look it up and it doesn't say that it is patent protected, that's one quick way to put yourself on notice that that nursery is not providing that information. And you may want to do a little bit more due diligence on the back end for their plants and their plant varieties. Use that Tennessee Extension Office table that I said screenshot. Reference that and create appropriate operating procedures around what plants you're using. And then even use colored markers for shrubs or trees, especially because it will be an ongoing issue. It would, you don't want to have a farm employee decide to graft something that, you know, they love that particular tree, they want to have more of that in the future, and they take it upon themselves to graft something, but it turns out it was a protected tree or shrub. Colored markers can help with that, of just putting a red marker on anything that you know you don't want to be grafting, because that would be an infringement of intellectual property rights. And that could be used for shrubs, for trees, or even for annuals, especially those flowers. I've noticed it was a lot of flowers that have those patent protections. And again, I'll reiterate, you're not likely liable for damages if you're not put on notice. So like, deep breath a little bit when it comes to infringement. If you didn't know and there was no way you could have found out that there was a patent protection on that, don't worry about the man just coming down on you. The farmer in the Monsanto case knew about the license with Monsanto. He knew about the expectations of using that patented seed, and he was being clever, and it ended up costing him, which is very unfortunate, because I think personally cleverness should be celebrated. But in that case, he was on notice. It was not something that he was completely blindsided for. So deep breath when it comes to infringement. You will be put on notice, and if you have not been put on notice, I won't say nobody will hold you at fault for that, but you can have that deep breath moment. And in the patent conversation, I think it's important to tie in the trade secret conversation. And here are the three elements of what a trade secret is. It's information with either actual or potential independent economic value by virtue of not being generally known. And that is a big mouthful of words that just saying it's some information that you have on your farm that is of value to you that people don't have access to necessarily. I'm sorry, I'm getting to the second point in that, but they don't generally know it. It's something you've thought through and a process that you've created that works really well. And then it has to have values to others who can't legitimately obtain the information. So if you found it on a YouTube video and you're calling that a trade secret, it's going to be difficult because somebody else can find that same piece of information on a YouTube video. The trade secret would more likely be a combination of things you might find on YouTube, and then it becomes your farm's systems or standard operating procedures. And the trade secret must be subject to reasonable efforts to maintain its secrecy. So this comes to the point of enforcement again. When you have intellectual property rights, it's up to you to enforce them. You are the person who, there's no enforcement agency besides you and your business. So when you have a trade secret, it's important to have non-disclosure agreements in place and for you to maintain that secrecy, to maintain that right. And I'll talk about non-disclosure agreements in just a minute. There we go. I'm trying to decide if I want to go ahead and talk about non-disclosure agreements or yes, I will. So non-disclosure agreements are one of those agreements that are going to have, it's going to have a use in the intellectual property realm, but it can also have a use just in employment in general. It will protect your trade secrets. It can protect any confidential information for your business when you start doing business with other folks or partnering for certain endeavors or new value-added enterprises. A non-disclosure agreement is going to protect your confidential information, especially trade secrets. In a non-disclosure agreement, you want to cover what information is confidential. You want to cover who has access. You want to clearly define who has access to the information, who may share the confidential information and with whom, and what are the consequences of sharing the information beyond the scope of the agreement. These are all the terms that you can think through and decide how protected you want this and what that looks like. Anecdotally, the founder of Hotmail had hundreds of non-disclosure agreements, even with his roommates and with friends and family, because he was talking about these ideas where they may have heard that. And that those non-disclosure agreements, even though it may have seemed really silly at the time, they were what protected his intellectual property rights enough to sell his information to Microsoft and make millions, it might have even been billions, a lot of money from his work with Hotmail. So non-disclosure agreements keep your IP yours for sure. They help protect that information. And then information or your ideas or your inventions that can be patented can often fall under the trade secret realm as well. They can kind of be either or in a lot of cases. So the question is, do you want to share the information or do you want to keep it private? And also, how long do you want that protection to last? Remember, a patent's going to last about 20 years. A trade secret will last indefinitely, as long as it's kept a secret. The Coca-Cola recipe for their soda is a trade secret. They never patented it, which is actually a really good business idea, because if it had been patented, by now it would be an open source available thing for anybody to use. But that chemical structure of their soda is a trade secret, and it is protected very vigilantly, and it works out for their business model. So thinking patent or trade secret, those two often dovetail in lots of ways. So you have to decide if you want to give that disclosure for a 20-year patent, or if you want to just protect your information within your business. And then if you know that you're going to be passing your business along to heirs in your estate, that trade secret becomes their intellectual property as well, and it can keep going on for the life of the business. So we will talk about avoiding intellectual property infringement in more depth. Before I move on to this avoiding IP infringement, again, are there any questions? We've talked about trademarks, we've talked about copyrights, We've talked about patents, plant protections, trade secrets. You have learned everything an IP focused person in law school learned in their law school career, and you did it in less than an hour and a half. Any questions? All right, then let's talk more about the avoiding intellectual property infringement piece and also enforcing your intellectual property. That'll go into this realm. So if you're someone who is concerned about infringing on somebody's intellectual property, if you're worried about just making the mistake of in upsetting somebody in the community, if you're worried about lawsuits, if you're worried about getting a cease and desist letter, if any of that stuff keeps you up at night, these are some of the things you can do to rest easy that you are not infringing on anyone's IP. The first is to perform a trademark search or copyright search or a plant variety protection search. Look for the marks. Look for that circle around the C, the circle around the R, the TM, the SM, the PP, the PPAF, all of those marks. Do market research. If you're ready to start making intellectual property a part of your business's portfolio, go ahead and get familiar with what's out there. My peach jam hypothetical, I would want to do a search engine search for peach jam in Georgia. Who's selling it? Who's selling it in North Carolina, South Carolina? What are folks calling it, and how can I set myself apart? So in doing the research for creating my IP, I'm doing the legwork for avoiding infringing on others' IP as well. Give credit. This goes to Chris's question about using a piece of information and then having the citations there. That is an excellent way to start showing that you did not intend to infringe anyone's IP. You make it very clear that this is the source I found this, and give them that credit. It's really hard to go after you for doing something wrong when you're trying your best to continue to give credit where credit is due. And then know what you agree to in your license agreements. Again, I'll use the Monsanto case to illustrate this. The farmer knew what was in those license agreements, and he was trying to be clever. Likewise, it can feel a little paralyzing of, well, what am I allowed to do and what am I not allowed to do in this intellectual property realm? But if you look over those agreements, ask nurseries to see the licensing and the royalty agreements for plant varieties and become familiar with what you can and can't do. You're going to empower yourself to feel a lot more confident to know what moves you want to make and with what plant varieties and such. Okay, I'm noticing that it is 8:18 and we're going to wrap things up at 8:30. So I'm going to go through this trademark search a little bit more quickly than I had planned on it. If you go home and try to do this, or if you try to follow along and you get lost right now, schedule an office hour with me. Let's do this one-on-one. Let's start thinking through what you want your trademark to be. We'll start doing these searches together. It's an extensive process to do this trademark search. So if you get lost here, I am still available to walk you through this and to be a support in your intellectual property endeavors. So you'll start with going to uspto.gov, and it's a different screen at first. I already hit trademarks at this point, and it'll pull up this menu. Then you'll click search trademarks. And when you do, it'll pull up the search trademark database for you. And you'll click search our trademark database. When you get to the trademark database, the TESS, there are multiple search options. There's a basic word search, which is just like what it sounds, where you can just put in the language you plan to use, the words you want to use. There are word and or design mark searches. that are structured and then also free-form. This free-form world is a world that you want to know what you're doing to get into it likely. So we'll start with a basic marked search for practice. And when you click that basic marked search, it's going to pull this page up that also has more options for designing your search. I didn't change anything in those options. And I entered sweet peach, going back to my hypothetical peach jam business. I entered sweet peach and then I hit submit query. And when I clicked that, it brought up 37 records of sweet peach being used in the registration database. And you'll notice this live and dead or live or dead. And then on this screenshot, you can see where it has the live or dead designation. Dead trademarks are no longer in use. So they may still be available for you to use if they're dead. That could be they just stopped using them. It could have been a trademark that became a generic word. There are a couple of reasons that it can die, but that's what that designation is talking about, is if that trademark is still being used and in what context. So of these first 14, I went ahead and just clicked on this first trademark that came up. So this is what I'm trying to trademark, is sweet peach. And it's there, but I don't get disheartened right away, because when I click that first item on the list, it pulls up that phrase, sweet peach, and this goods and services line gives me more context about that trademark. It's being used for retail clothing boutiques. I'm selling peach jam. So even though this person has a registered trademark, sweet peach, it's being used in a different realm. So likely I still have access to that trademark that I want to apply for. And other information that I gleaned from this page right here is that the mark was registered in 2021 and is still live. And I also gleaned from this, especially going back to these 37 records that came up with sweet peach, I gleaned that this is only the beginning of my search. Like I mentioned, doing market research is important. Know your market, know what you're doing and around, in what structure and what framework, what else is out there. And there may be 37 more trademarks that I need to go through. And I also may want to design more searches to see if anything else comes up that didn't come up in that basic word search. Again, this is something we can do together in office hours. Now, when it comes to protecting your IP, these are two ways of keeping a vigilant eye out for who might be infringing on your trademark, on your copyright, knowingly or unknowingly. This isn't about getting somebody or just being out to get folks. This is to uphold the rights that you have in your intellectual property, to uphold the value of them, to making sure that you maintain your rights to your IP are what maintains the value of them, especially if they're a big part of your business model. So when it comes to protecting your IP, doing market research regularly gives you an idea and gives you a pulse on who may be sort of sliding into your realm of IP and maybe getting too close for comforts, starting to ride on that good name that you have created for yourself. So again, know who's out there, what are they doing, what are they calling it? And then search engine searches help here too. You can Google your trademarks regularly. You can Google phrases and keywords in your copywritten material and see what comes up. Is somebody else using it? And maybe, especially, not just maybe, especially in this social media world and the internet world where folks kind of just, pick and choose, it may have been a complete overlook of the fact that they were using your information that is protected by IP classifications. So market research and search engine searches are a great way to keep an eye and keep a pulse on who may be using your work. And if you find that somebody is using something that belongs to you without your permission, remember you may have given it to them in a license, you may have had that conversation, but even with a license, they can overstep those bounds. So in any of those cases, drafting a cease and desist letter is going to provide notice to an infringer that they are infringing on your intellectual property. When you write this letter, it doesn't have to be anything fancy. It doesn't have to be on legal letterhead. It doesn't even have to be on your own business's letterhead. It can just be a letter. It can be handwritten even. It's just a matter of conveying the right information. You want to let the infringer know that they're infringing upon your intellectual property. You may want to include a registration number for your intellectual property or give that context of what protection it has and how they can go look for themselves that it's protected. Give them a time frame for remedy. For any electronic uses of intellectual property, a week is plenty of time for them to take it down, a week of receipt of that letter. And again, sending certified mail return receipt is really smart for cease and desist letter issues if you're handling them yourself. That way you have context of when they got it, and then you can hold that time frame, hold them to that time frame. So give a time frame for them to fix the issue, because that's really what's important, is just that you have credit or they're not using it at all, whatever you need done, give them a chance to do it, because that's what's most important, is that they stop using your intellectual property without your permission, without that right being given to them. A cease and desist letter is going to assert what action will be taken moving forward. And likely this is a lawsuit. So you will let them know you are infringing, you have a week to take this down. If it's not taken down, I will be filing a lawsuit. Or if you're handling cease and desist letters on your own, you could even add the extra layer of, I will seek an attorney if it's not taken down by them. So you can kind of decide what action you would take next, what would be the next step for you, and be a little bit transparent about that. Threatening federal litigation right off the bat with a handwritten note has teeth, if you ask me, because you could still go file that lawsuit even without an attorney. But there may be more progressive steps, especially if you're not losing money like right away because of this. You may want to give it a little bit more time before more serious action. And keep in mind also that cease and desist letters are not required before you file a lawsuit. If someone's infringing upon your IP, and you especially have those registrations, if it is part of your bottom line, it's part of your business model, and you're ready to enforce those intellectual property rights, you don't have to write a cease and desist letter first. You can go straight to the lawsuit if need be, if there's reason for that. And I'm happy to talk through that strategy with you at any time in an office hour. All right, so the takeaways from tonight is that intellectual property is another asset for your farm or food business. There are different types of intellectual property that apply to various value-added products on farms. License agreements and non-disclosure agreements are tools for sharing and maintaining intellectual property rights. And enforcing intellectual property rights is your job. And lastly, cease and desist letters are an effective tool for enforcement when you are enforcing those rights. And if you have more questions, sign up for an office hour. Again, thank you, Foodwell Alliance, for the generous support and allowing the law farm to be a resource provider organization. Part of that resource provider organization relationship means that farmers have access to a practicing attorney to talk through these issues one-on-one. That link, calendly.com/thelawfarm/office hours, is the way to sign up. If your farm operation is in Clayton, Cobb, DeKalb, Fulton, or Gwinnett counties, these office hours are completely free. If you're outside these counties, I'm offering these office hours to webinar participants for $75. Y'all, it costs $250 to just have a working consultation for an hour with me. If If you're in Clayton, Cobb, DeKalb, Fulton, or Gwinnett, that is paid for you. It is completely free to you to meet with me one-on-one, and it's $75 if you're outside that area. So please take advantage of this incredible opportunity to work side by side with an attorney to get your legal foundation of your business on point. And you can always contact me at michelle@thelawfarm.com if you have any questions. And one more exciting piece, you're going to be getting a follow-up email to this, and there's a chance to win $50 in an e-gift card just by giving us some feedback. I have a survey, and if you fill out that survey, you'll be entered to win that $50 gift card. I appreciate your feedback. This resource is for you, so we want to tailor it to be of best service. That's all I've got tonight. Thank you so much for being here. If you have questions, feel free to stick around. I'll be here for another minute or two. But thank you so much for sharing your time with me tonight. And I look forward to seeing you at an office hour.